Trial. The formal judicial proceeding in which the parties present evidence and arguments to a judge or jury, who then apply the law to the facts and render a verdict resolving the dispute between the parties. Bench trial. A trial in which the judge serves as both the legal authority and the fact finder, deciding all questions of law and fact without a jury, typically chosen when the parties waive their right to a jury or when the case involves complex legal issues better suited to judicial determination. Jury trial. A trial in which an impartial panel of citizens serves as the fact finder, evaluating the evidence presented and rendering a verdict based on the judge's instructions about the applicable law. Trier of fact. The person or body responsible for evaluating the evidence and determining what actually happened. The jury in a jury trial or the judge in a bench trial, as distinguished from legal questions decided exclusively by the judge. Trier of law. The judge, who in every trial, whether jury or bench, has exclusive authority to decide all questions of law, including rulings on evidence, jury instructions, and the legal sufficiency of claims and defenses. Docket. The official court calendar listing all cases scheduled before the court on a given day or period, as well as the complete log of all filings, orders, and proceedings in a particular case. Call of the calendar. The court's formal announcement at the start of a session listing the cases scheduled that day, during which attorneys confirm their readiness to proceed or request continuances. Case in chief. The main body of evidence and testimony presented by each party in support of their position, beginning with the plaintiff or prosecution and followed by the defense, before any rebuttal evidence is offered. Opening statement. The attorney's initial address to the jury at the start of trial, previewing the evidence they intend to present and the story of the case from their client's perspective, serving as a roadmap rather than argument. Closing argument. The attorney's final address to the jury after all evidence has been presented, summarizing the evidence, arguing its significance, applying it to the law, and urging the jury to return a verdict in their client's favor. Rebuttal. Evidence or argument presented by the plaintiff or prosecution in response to the defendant's case in chief, limited to addressing the specific points raised by the defense rather than introducing entirely new matters. Surrebuttal. A limited additional presentation by the defense responding specifically to new matters raised during the plaintiff's or prosecution's rebuttal, permitted only at the court's discretion. Rest. The formal declaration by an attorney that their party has concluded presenting evidence, signaling to the court and opposing counsel that the case in chief or rebuttal is complete and the other side may proceed. Motion for directed verdict. A motion made immediately after the opposing party rests, asking the judge to rule that the evidence presented is legally insufficient to support a verdict in that party's favor and to end the case without jury deliberation. Voir dire. French for to speak the truth, referring to the process of questioning prospective jurors before trial to determine their suitability to serve, uncovering potential biases, conflicts of interest, or prior knowledge of the case. Venire. The pool of prospective jurors summoned to the courthouse from which the trial jury will be selected through the voir dire process, drawn from voter registration rolls, driver's license records, or other public lists. Juror. A member of the jury selected through voir dire to hear the evidence at trial and participate in deliberations, sworn to decide the case fairly and impartially based solely on the evidence and the judge's instructions. Alternate juror. An additional juror, selected beyond the required number, who hears all of the evidence at trial, but participates in deliberations only if a regular juror becomes unable to continue due to illness, misconduct, or other cause. Challenge for cause. An attorney's request to remove a prospective juror from the panel based on a specific articulable reason demonstrating that the juror cannot be fair and impartial, such as a relationship with a party, prior knowledge of the case, or demonstrated bias. Peremptory challenge. An attorney's right to remove a limited number of prospective jurors without stating any reason, available to both sides as a tool for shaping the jury, but constitutionally prohibited from being exercised on the basis of race or gender. Batson challenge. An objection raised when a party believes the opposing attorney has used peremptory challenges to exclude jurors based on their race, requiring the challenging attorney to offer a race-neutral explanation for each disputed strike. Jury panel. The group of prospective jurors assembled in the courtroom for voir dire questioning before the final jury is selected, from which jurors will be accepted, challenged for cause, or removed by peremptory challenge. Sequestration. The isolation of jurors from the public, media, and outside influences during a high-profile trial, typically involving housing them in a controlled environment to prevent exposure to prejudicial information outside the courtroom. Jury foreperson. The juror elected or appointed by the other members of the jury to preside over deliberations, facilitate discussion, ensure all voices are heard, and announce the verdict when deliberations are complete. Objection. A formal protest raised by an attorney during trial challenging the admissibility of evidence, the propriety of a question, or the conduct of opposing counsel, requiring an immediate ruling from the judge before the proceedings continue. Sustained. The judge's ruling agreeing with an objection, meaning the objection is valid, the question or evidence is disallowed, and the witness must not answer, or the evidence must not be admitted. Overruled. The judge's ruling disagreeing with an objection, meaning the objection is denied, the question or evidence is permitted, and the witness may answer, or the evidence may be admitted. Standing objection. A continuing objection to an entire line of questioning or category of evidence granted by the judge to allow the objecting attorney to preserve their objection for the entire subject area without having to object individually to each question. Preservation of error. The requirement that an attorney make a timely and specific objection at trial in order to preserve the right to raise that issue on appeal. Failure to object generally waives the right to complain about the error later. Offer of proof. A statement made by an attorney outside the jury's hearing explaining what evidence or testimony they would have introduced had the objection been overruled, made for the record to preserve the issue for appellate review. Record. The official transcript of everything said during trial, including all questions, answers, objections, rulings, and arguments, which serves as the basis for any subsequent appeal of the verdict or rulings. Sidebar. A private conference held at the side of the judge's bench between the judge and the attorneys, out of the jury's earshot, to discuss legal issues, objections, or sensitive matters without influencing the jury's perception of the case. Bench conference. Another term for a sidebar, referring to any private discussion between the judge and the attorneys conducted at or near the judge's bench rather than in open court or in chambers. In camera. Latin for in the chamber, referring to proceedings or inspections conducted privately in the judge's chambers or outside the presence of the jury and the public, often used for reviewing sensitive evidence or discussing privileged matters. Chambers conference. A meeting between the judge and the attorneys held in the judge's private office rather than in open court, used for informal discussions about scheduling, settlement, legal issues, or matters requiring privacy. Leading question. An objection raised when an attorney asks a question on direct examination that suggests the desired answer within the question itself, improperly coaching the witness rather than allowing them to provide their own account. Assumes facts not in evidence. An objection raised when a question contains an embedded assumption about a fact that has not yet been established in the record, effectively asking the witness to confirm something that has not been proven. Compound question. An objection raised when a single question actually contains two or more separate questions, making it impossible to know which part the witness is answering and creating confusion in the record. Argumentative. An objection raised when an attorney's question is not genuinely seeking information, but is instead making an argument, badgering the witness, or attempting to draw a legal conclusion rather than elicit factual testimony. Asked and answered. An objection raised when an attorney repeats a question that has already been asked and answered, either to emphasize a point, pressure the witness, or waste time without any new information being sought. Calls for speculation. An objection raised when a question asks the witness to guess, imagine, or speculate about facts they do not personally know, requiring them to go beyond their actual knowledge and observations. Calls for a legal conclusion. An objection raised when a question asks a lay witness to offer a legal opinion or characterization, such as whether someone was negligent or acted in self-defense, matters reserved for the court or the jury to decide. Narrative. An objection raised when a question invites the witness to give a lengthy, open-ended narrative response rather than answering specific questions, reducing the opposing attorney's ability to object to particular statements as they are made. Vague and ambiguous. An objection raised when a question is so unclear or imprecise that the witness cannot reasonably understand what is being asked, potentially resulting in a misleading or uninformative answer. Mischaracterizes the testimony. An objection raised when an attorney's question inaccurately summarizes or distorts what the witness previously said, either deliberately or carelessly, creating a false impression in the jury's mind. Beyond the scope. An objection raised during cross-examination when the questioning attorney ventures into subject matter that was not covered during direct examination, exceeding the permissible boundaries of cross-examination. Harassing the witness. An objection raised when an attorney's questioning crosses from vigorous cross-examination into personal attacks, intimidation, or conduct designed to embarrass or demean the witness rather than test their testimony. Badgering the witness. An objection raised when an attorney persistently repeats questions, argues with the witness, refuses to accept their answers, or uses an aggressive tone that goes beyond permissible advocacy and into harassment. Cumulative. An objection raised when evidence or testimony is repetitive of what has already been presented, adding nothing new and serving only to emphasize a point already made, wasting the jury's time. Lack of foundation. An objection raised when an attorney attempts to introduce evidence or elicit testimony without first establishing the necessary background facts to show that the evidence is authentic, reliable, or within the witness's personal knowledge. Lack of personal knowledge. An objection raised when a witness attempts to testify about facts they did not personally observe or experience, going beyond what they actually know to offer second-hand information or mere assumption. Hearsay. An objection raised when a witness attempts to repeat an out-of-court statement offered to prove the truth of the matter asserted, one of the most frequently raised and most complex objections in trial practice. Relevance. An objection raised when evidence or testimony has no logical connection to any fact at issue in the case, serving only to confuse, distract, or prejudice the jury without contributing to the determination of the disputed facts. Unfair prejudice. An objection raised when evidence, though technically relevant, carries such a high risk of inflaming the jury's emotions or encouraging improper reasoning that its prejudicial effect substantially outweighs its probative value. Authentication. An objection raised when the offering party has not established sufficient foundation to show that a piece of evidence is what they claim it to be, such as failing to verify the source of a document or the accuracy of a photograph. Best evidence. An objection raised when a party attempts to prove the contents of a written document through testimony or a copy rather than producing the original, unless the original's absence has been satisfactorily explained. Privilege. An objection raised when a question or document request would require disclosure of communications protected by a recognized privilege, such as attorney-client communications or spousal confidences. Chain of custody. An objection raised when the offering party cannot adequately account for where a piece of physical evidence has been since it was collected, raising the possibility that it has been altered, contaminated, or substituted. Character evidence. An objection raised when a party attempts to introduce evidence of a person's general character traits to prove they acted in conformity with those traits on a specific occasion, generally prohibited by the rules of evidence. Prior bad acts. An objection raised when a party attempts to introduce evidence of a witness's or party's prior misconduct or uncharged crimes to suggest they have a propensity to behave badly, generally inadmissible for that purpose. Improper opinion. An objection raised when a lay witness attempts to offer an opinion or conclusion that goes beyond their personal observations and into matters requiring specialized expertise they do not possess. Improper expert opinion. An objection raised when an expert witness offers an opinion that exceeds the boundaries of their qualified area of expertise, relies on an unreliable methodology, or is not sufficiently connected to the facts of the case. Parole evidence. An objection raised in contract cases when a party attempts to introduce evidence of prior oral or written negotiations to alter, contradict, or supplement the terms of a fully integrated written contract. Overrule. The judge's command denying an objection and allowing the question, evidence, or testimony to proceed, after which the witness must answer and the evidence may be considered by the jury. Sustain. The judge's command granting an objection, directing that the question not be answered, the evidence not be admitted, or the improper conduct cease immediately. Strike. The judge's order removing specific testimony or evidence from the record after it has already been heard by the jury, typically followed by an instruction directing the jury to disregard what they heard. Disregard. The judge's instruction to the jury to completely ignore something they have already heard, seen, or been told, legally requiring them to treat it as if it never occurred. Though the practical effectiveness of this instruction is a subject of ongoing debate. Rephrase. The judge's direction to an attorney to restate a question in a different and more appropriate form, typically given after a sustained objection, rather than simply shutting down the line of inquiry entirely. You may answer. The judge's signal to a witness that an objection has been overruled and they are now permitted to respond to the question that was asked, resuming the testimony after the brief interruption of the objection. The witness will refrain. The judge's command directing a witness to stop speaking, either because they have answered beyond what was asked, volunteered inadmissible information, or are otherwise speaking out of turn. Counsel will approach. The judge's invitation or directive for the attorneys to come to the bench for a sidebar conference, removing the discussion from the jury's hearing without the formality of a full recess. You may step down. The judge's formal release of a witness from the witness stand, signaling that their testimony is complete and they are no longer subject to further examination. Order in the court. The judge's command demanding silence and decorum in the courtroom, typically delivered when spectators, parties, or witnesses are creating a disturbance that interferes with the orderly conduct of the proceedings. The court will come to order. The formal call to attention delivered by the bailiff or the judge at the beginning of a court session, signaling that proceedings are about to begin and commanding the respect and attention of everyone in the courtroom. All rise. The bailiff's command directing everyone in the courtroom to stand when the judge enters or exits, a gesture of respect for the authority of the court and the judicial office. Be seated. The judge's or bailiff's command permitting everyone in the courtroom to sit after standing for the judge's entrance, signaling that the session is formally underway and proceedings may commence. Counsel. The judge's form of address when speaking directly to an attorney during trial, used in place of the attorney's name as a sign of professional decorum and to maintain the formality of the proceeding. The court finds. The judge's formal declaration of a legal ruling or factual determination, used when announcing decisions on motions, evidentiary issues, or findings of fact in a bench trial. So ordered. The judge's formal confirmation that a ruling, agreement, or stipulation has the force of a court order, typically spoken aloud or written on a document to give it official legal effect. Recessed. The judge's declaration that court proceedings are temporarily suspended for a break, whether for a few minutes, overnight, or for a longer period, after which proceedings will resume. Adjourned. The judge's declaration formally ending a court session for the day or until a specified future date, distinct from a recess in that adjournment, signals the conclusion of the day's proceedings. Deliberation. The private process by which the jury collectively reviews the evidence, applies the judge's legal instructions, discusses the case, and works toward a unanimous verdict after all testimony and argument has concluded. Jury instructions. The judge's formal directions delivered to the jury before deliberations, explaining the applicable law, defining legal terms, describing the burden of proof, and instructing the jury on how to evaluate the evidence. Pattern jury instructions. Standardized, pre-approved jury instructions developed by courts or bar associations for common legal issues, used as a starting point that attorneys may propose modifying to better fit the specific facts of the case. Charging the jury. The formal process of delivering the final jury instructions, representing the judge's last opportunity to ensure the jury understands the legal framework within which they must decide the case. General verdict. The most common form of jury verdict in which the jury simply announces who wins and, in civil cases, the amount of damages awarded without specifying how they resolved each individual factual or legal issue. Special verdict. A verdict form requiring the jury to answer specific factual questions rather than simply declaring a winner, after which the judge applies the law to those findings to determine the legal outcome. Special interrogatories. Written questions submitted to the jury along with a general verdict form, asking them to specify their findings on particular factual issues so the court can verify that the verdict is consistent with those findings. Verdict form. The official document given to the jury that structures their deliberations by presenting the questions they must answer and the format in which they must express their verdict. Unanimous verdict. The requirement in most criminal cases that all jurors agree on the verdict, reflecting the high stakes of criminal conviction and the constitutional requirement that guilt be proven beyond a reasonable doubt to every member of the jury. Hung jury. A jury that is unable to reach the required unanimous agreement after extended deliberations, resulting in a mistrial and leaving open the possibility of retrial before a new jury. Allen charge. A supplemental jury instruction, sometimes called the dynamite charge, given to a deadlocked jury urging them to make a renewed effort to reach a verdict, reminding minority jurors to carefully consider the views of the majority while not surrendering their honest convictions. Poll the jury. The process of individually asking each juror after the verdict is announced whether the verdict as stated is truly their own verdict, ensuring that the decision was reached voluntarily and without coercion. Jury nullification. The phenomenon in which a jury returns a verdict of not guilty despite believing the defendant committed the charged offense, exercising their de facto power to decline to apply a law they consider unjust, though courts do not officially recognize or encourage this practice. Sequestered jury. A jury that has been isolated from the public and media during deliberations, or throughout the entire trial, to prevent exposure to outside influences that could compromise the fairness of their verdict. Mistrial. A judge's declaration that the current trial is void and must begin again from the start, typically triggered by juror misconduct, a fundamental error, inadmissible evidence exposed to the jury, or the jury's inability to reach a verdict. Motion for mistrial. A formal request by an attorney asking the judge to declare the proceedings null and void, typically based on an event so prejudicial that the jury cannot be expected to decide the case fairly regardless of any curative instruction. Curative instruction. The judge's instruction directing the jury to disregard something improper they have been exposed to, offered as an alternative to a mistrial when the court believes the jury can follow the instruction and still decide the case fairly. Double jeopardy. The constitutional protection preventing the government from retrying a defendant after an acquittal, though a mistrial caused by manifest necessity, such as a hung jury, generally does not bar retrial. Manifest necessity. The legal standard that must be met before a judge may declare a mistrial over a defendant's objection, requiring that there be an overwhelming and urgent need to end the proceedings that cannot be addressed by any lesser remedy. Prejudicial error. An error during trial so significant that it likely affected the jury's verdict, warranting either a mistrial if caught during trial or a new trial if discovered afterward, as opposed to a harmless error that had no effect on the outcome.